Welcome back to Supreme Court Now. My name is Luis Cited, and today we're going to be looking over 3 more cases that the United States Supreme Court is going to be looking at during the current October 2020 term. And we're going to skip Monday, October the 12th, because that is a holiday for the Supreme Court justices, and go straight into Tuesday, October the 13th. They're going to be looking at 3 cases, the first being United States versus Briggs, the second, United States versus Collins, and the third, the City of Chicago versus Fulton. And with that, let's get into our cases. United States versus Briggs and United States versus Collins. It's important to note that these 2 cases are going to be consolidated together. That basically means that the Supreme Court is going to look at both of these cases as one. So for this, Briggs and Collins, both in the military, both committed the same crime and are both being tried by the United States Attorney General. So in the Supreme Court's eyes, they're going to look at both of these cases as one. So Michael Briggs was found guilty of rape in 2014 by court-martial for a rape that he committed in 2005. And after he was found guilty, Briggs appealed to the United States Air Force Criminal Court of Appeals. And so it's important to note that while you and I, when we appeal a case, it's going to go to one of the 11 circuits in the United States. So, for example, I live in Texas, and I fall under the 5th Court of Appeals in New Orleans. However, because active servicemen fall under martial law, they're subject to different rules that you and I are. They see different judges, and thus they're subject to different appellate courts as well. And after Michael Briggs appealed his case to the United States Air Force Criminal Court of Appeals, basically his argument was that, look, this case is past the statute of limitations. And the statute of limitations basically means it's the maximum amount of time after an event where legal proceedings may be initiated. So in his case, the crime happened in 2005, yet he wasn't tried, nor was it discovered until 2014. In the military, the statute of limitation is 5 years. So in his eyes, he can't be prosecuted for a case that's past the statute of limitations because, after all, this has been 9 years, a lot more than 5 years. And in fact, he wins the case, and the United States Air Force Criminal Court of Appeals finds him. It's not that they don't find him guilty, right? This has nothing to do with whether he committed the crime or not. This is whether they have the grounds to actually prosecute him because it's been past the threshold of 5 years. And so with that, Briggs was free to walk, or basically is what he thought. When later, the United States District Attorney picks it up, and they're going to try him for the same case, yet on different grounds. So now that this case is reopened, the United States is basically going to bring the question up and argue that all military crimes punishable by death are exempt from limitations. And so with that, they have to argue that rape in the military is punishable by death. And because it is, the statute of limitations are out the window. Therefore, the reason that he got his case off is invalid now. And in order for them to prove that rape is punishable by death, well, let's look into martial law, or the Uniform Code of Military Justice. Specifically, Section 920, subsection A, where it says, members of the military who commit, quote, sexual intercourse by force and without consent is guilty of rape and shall be punished by death, end quote, or just punishment deemed by martial law. So with that code, the United States basically has clear grounds that says, hey, look, rape in the military is punishable by death. It says so right here in the Military Code of Law. So if it's punishable by death, then limitations don't apply to it, and therefore Mr. Briggs and Mr. Collins as well, because these cases are consolidated, their argument that the allegations were past the 5-year statute of limitations are out the window. They can still be tried as normal, right? However, the case is not this cut and dry, and the Supreme Court is going to have to look at a really big picture here, and this is why I think this case could be a really strong precedent for cases for years to come. We have to look at, do members of the military who are subject to martial law, are they also subject to the same laws that you and I are subject to? And more specifically, the 8th Amendment, right? And let's remember the 8th Amendment prohibits cruel and unusual punishment. And so let's look to precedented cases by the Supreme Court, and specifically in 1977. The case Coker versus Georgia, where Coker was sentenced to death by the state of Georgia for the rape of a woman. However, the Supreme Court reversed this and says that unless the victim was killed during or after the crime committed, rape is not punishable by death. Not saying that it can't be a capital punishment and they can't be sentenced to life, but it cannot be punishable by death. And so let's look at another case that rules the same in 2008. It's Kennedy versus Louisiana, where Kennedy was also tried to death for the rape of a child. And child in the state of Louisiana would be anybody under the age of 12. And so he was sentenced to death. However, the Supreme Court went ahead and did the same thing as they did in 1977. They said that even though this is a child, rape is not punishable by death unless the victim was killed during or after the crime. And so with these two, basically what the Supreme Court has ruled on twice is that rape is not punishable by death. So this brings us back to the United States' argument from before. Is rape punishable by death? And with that, we have two laws that contradict each other. We have the martial law, which says that any military person who commits rape is subject to death. And then we have the Eighth Amendment, which said unless the victim is killed, rape is not a punishable crime by death. So I think the big question that the Supreme Court is really going to look at is, do members of the military, while they are subject to martial law, are they also subject to the law that you and I are subject to? And so I think this is going to be a really big case. I apologize because it is a pretty dire subject, but it's something that's going to be really important. It's going to be interesting to see what the Supreme Court decides on. And with that, we'll move on to the next case, which is Chicago versus Fulton. And so this case is maybe more small fry compared to other cases that I think the Supreme Court has seen this term. Nevertheless, they're still seeing it, so we'll still review it. So, Robin Fulton, her car was towed and impounded by Chicago Police Department because of an unpaid citation in December 2017. The citation was she was driving on a suspended license, and she never paid the citation to the city, and she never showed up to court. And just a month later, in January of 2018, Ms. Fulton filed Chapter 13 bankruptcy. And in that bankruptcy, the next month in February, she filed a payment plan and named the city of Chicago a general unsecured creditor. And that basically means that this is normally used in less professional circumstances. So say I need $5,000 cold hard cash to finish out my last semester of college, and say I'm real good friends with my next door neighbor, and I ask my next door neighbor for the money, they lend it to me. They're a general unsecured creditor because they have no collateral with me. I didn't leave them my car. I didn't leave them the title to my house in case I don't pay them back. They have no collateral. And what Ms. Fulton's saying is that this is the city is a general unsecured creditor, and they cannot keep her car until she pays her debts. As a response to this, Chicago filed an unsecured proof of claim with an undisclosed amount of what Ms. Fulton owed them, and they claimed that they were a secured creditor, and in fact they do have the right to keep her car as a collateral until she pays her citations, regardless of the status of her bankruptcy. And later that year, in May 2018, a bankruptcy court ruled that the city of Chicago must return the car to Ms. Fulton, and if not, they would be charged a $100 fine each day the car is not returned. So the city complied with the ruling and gave Ms. Fulton back her car. However, as soon as they gave back her car, they were right on starting their appeals case. And in their appeals case, they bring up the means of the U.S. Code, Title 11, Chapter 4, Section 363. And with that, the question arises is whether an entity that is passively retaining possession of a property, the entity being Chicago, the property being Ms. Fulton's car, in which a bankruptcy estate has an affirmative obligation under the bankruptcy code to return that property to the debtor or trustee immediate upon the filing of a bankruptcy petition. And so with that, Chicago is basically saying, look, regardless of Miss Fulton's filing of the bankruptcy petition, which may seem a little sketchy, not sketchy, but it's just an awfully close coincidence that her car was towed and impounded in December of 2017, and just a month later she files for bankruptcy. Now, not that that has anything to do with the case, but I think that for the Supreme Court, they have to look at all underlying circumstances, and I think this is one of them, right? Her car gets towed, and just a month later she files for bankruptcy. Not saying that it has anything to do with the case, but I just think it's something that the Supreme Court will take into consideration. And Chicago is saying, hey, look, because we're an entity that's passively retaining this collateral until the debt is repaid to us, we don't have to give it back to her, whether or not they claim bankruptcy. Because in fact, because they claim bankruptcy, really all of her assets and accounts are diminished. They're froze. And so that's what the Supreme Court's going to be looking at on Tuesday, and we will see what their ruling is. And with that, thank you guys for watching. Those are the cases for Tuesday, October the 13th, 2020. Be sure to stay tuned, as I will be covering the rest of the cases that the Supreme Court will be covering as well during the rest of this 2020 through 2021 term. And with that, adios.